Hi, I'm Art Bergeron, and welcome to this installment of Frank and Mary here in Hudson. As you know, if you've followed these shows before, my day job is as an elder law attorney at Myrick O'Connell, where I do nothing but elder law. But this show it typically is not designed to be about elder law, but rather to be about my friends Frank and Mary. If you've been to my presentations at the Senior Center before, you've seen Frank and Mary. Their kids, Peter, Paul, and Mary Jr., you know that their goal in life is to live in their house until they die and be buried in the backyard. You've heard me say this a million times. And the goal of the show is to really talk about people you need to know and programs you need to know about as a senior in order to do exactly that, to stay in Hudson like forever until you die and be buried in the backyard. So, and by the way, my next month's presentation is going to be about Medicare. It's because it's November, because it's now open enrollment. And I try every year to use the November show in order to really encourage people to not just take what you're now doing for granted in terms of what you have for Medicare, but to really take the opportunity to look at what you've got and see if there's really something that you can do better. So for this show, I want to talk about, though, an issue that no senior really wants to face, but that sometimes seniors do have to face, and that's family feuds. I had hoped to get one of my colleagues here who does nothing but family feuds to come on the show, but she had a scheduling conflict today. But I decided that I would talk to you about that because I think it's really an important topic and one that oftentimes folks don't talk about. And I guess the reason why I wanted to talk about it was from your perspective. I want you to think about whether, first of all, if you're in the middle of one of these family feuds, to know kind of what your options might be. But secondly, I want you to think about whether there are some things that you could do to avoid having this kind of situation happen to you. So if you're like my friends Frank and Mary, and you've got some kids, and when you think about your estate plan often is that when you die, you're going to simply have the assets divided up among your kids, and that's all great. And as a matter of fact, if that's your estate plan, you don't even need a will to implement that, because that is exactly what would happen if you died without a will. If you died without a will and your spouse is alive, then all assets would go to your spouse. If you died without a will, your spouse is dead, and your children are still alive, then all assets are going to be divided equally among the kids. But there are some issues that often come up after you die, which cause or are the result of things that you never wanted to have happen. I know I have so many clients who will say, I never want my death or any of this to be a cause of friction among my kids. But sometimes it is. Sometimes it is. So I just want to talk about, first of all, the kind of most common causes of friction, the most common family feuds, and then talk to you a little bit about some things that you might want to think about doing in order to avoid those family feuds. So, first of all, I want to talk about the feuds that may occur after you die. And so, of course, from one perspective, you don't really care about those because you're dead. And so, as I always tell people, there are many theories about what happens after you die. Maybe you go to heaven or hell, or maybe you get, reincarnated as something else, who knows? But in none of those theories are you especially concerned at that point about the arguments among your kids. But, it may bother you now, the thought that after you die, your kids, are just going to be fighting over something that you maybe could have prevented. So I just want to talk about that a little bit. So there are three main reasons for family feuds. One of them is money. And that's probably the most common reason why there is a family feud, at least one that gets to the level that people are hiring lawyers to fight, because they're paying the money to hire the lawyers to fight because there's money to be won or money to be lost if they don't fight. And so typically family feuds are about money. There are a few unusual cases, and I was hoping my colleague would be on so that she could tell you about this one case that she said she had many years ago, where there was a significant fight, and there were several siblings fighting over who was going to get the cardboard Santa that had always been put in their parents' front yard at Christmas, and who was going to get that. And so the folks that we represented in that feud spent probably about $30,000 in attorney's fees. We have no idea how much the other feuding siblings spent on their lawyers. It was a gigantic amount of money. Now, in that particular case, this was obviously not about the money. There was something else that was going on. And I guess that leads to the second major reason for family feuds, which is bad blood. And you may be one of those people who has been rarely blessed in that you have children who maybe have always gotten along and now get along, and you think will continue to get along, and that's terrific. And it may be that as a result of your death, and I'll talk as a result of money and ambiguity, that bad blood will arise among them, right? But the point is, right now everybody's getting along. It may be, though, that you have a family where that what I just described, regrettably, is not the case, where there is bad blood now involving one or more of your children, and you have a concern, or should have a concern, that bad blood may spill over if you get ill or if you die, because those two things, you're getting ill and you're dying, are some of the most common causes of family, well, I'll call family dysfunction, becoming even more dysfunctional, right? So, but if you already know that there is bad blood, it's for that reason that you really, really want to be careful in terms of what your estate plan is. And that leads to the third reason why there are these kinds of family feuds, and that is ambiguity. Ambiguity. And the problem with trying to solve an ambiguous, a problem that you left ambiguous when you died, is that you're dead. So that while there would be no question while you were alive about how your assets would be handled, if you wanted to give them away, you can just give them away. I mean, like, they're your assets, right? But if you're dead and it's not clear how things need to be given away, that's when the feuding may start, especially if there's bad blood to begin with. So let me just kind of talk to you about a couple of those, or three of those kinds of feuds, and kind of how you may be able to avoid them. The first one, which people think is the most common family feud, excuse me, is the will contest. There's a will that you did, and it said everything gets divided in a particular way. And somebody is not really happy about that. And so they contest the will. Typically, that doesn't happen if, as in the example that I gave, you're simply saying that after you die, everything gets divided equally. It more often happens if the will contains some kind of unusual division, typically because either one of your children you feel just needs more in resources, or because they have problems, or they need less in resources because they don't have problems and they're adequate financially, or you feel you've already taken care of them because you've made gifts to them or loans that they haven't repaid. I've heard all of these stories, right? So there are in those kinds of cases, those are the cases where typically someone will say, well, that will, I'm going to contest that will. Now, there are very few reasons that anyone can contest a will. There are only three really. If your will was made while you were of sound mind, and was made without your being under duress, so that it was your free act. And if you were over 18, then whatever that will says, that's going to stand. Nobody's going to be able to challenge that will. So the question that's going to come up, or the only way that a will challenge can occur, or can succeed, is if someone can show that forget about the 18, we're all older than that. So if someone can show that you either were not of sound mind, or that you signed under duress. And often those two questions kind of get blended together, because the challenge becomes that, oh, ma or dad was slipping, that they weren't really on top of their games, and therefore they kind of either didn't know what they were signing, or they really didn't have the mental capacity to process it. And someone, typically the one who was favored in the will, was exerting undue influence over the parent, over the person who was slipping. So if there's going to be a challenge, that's going to be the basis for the challenge. So if you are concerned about that, and you're concerned about others challenging the fact that you may have favored one of the children, a couple of things. You want to make sure that the will that is executed is done as soon as possible. If you're thinking about doing that now, or if you're thinking that you may want that kind of distribution, do it now, because you don't know what your health is going to be like in 3 months or 6 months or 9 months. I know that there's a challenge that is going on right now, with a now deceased client, where there was an original will where a person left most of what she had to her brother, and then the rest to the brother's children. But then shortly before she died, in this case, not like on the day of her death or anything, but like 3 months before she died, she changed the will to leave everything to the brother. Well, now, and apparently, and I had some inkling of this before all of this happened, but it's more clear now. There is some friction between the brother and the brother's children, and so now the brother's children are challenging the will. And the question is going to be, given the fact that this change was made 3 months before this woman died of cancer, the question is going to be whether or not that person was competent to sign at the time. It's a lot harder to make that challenge if the will was signed a year before, right? The other thing that you can do to kind of reduce the chances of that challenge would be to make sure that you have witnesses at the time that the will is made, who are witnesses whom you know, and who may really be able to testify if this matter gets tried, goes to a trial, may be able to testify as the witnesses that when they saw you sign, they had a lot of reason to believe that you knew what you were doing, and that you were not signing under duress, and that you were of sound mind. So if you have a will, then those are the things that you want to think about in order to try to make sure the will doesn't get challenged. A second way to avoid that problem, though, is to avoid having the will get probated at all. Now, and you're going to hear me talk about this kind of several times during this presentation. If this is a concern of yours, then you, more than most people, want to make sure that your estate execution after you die avoids the probate process. Because if you die owning assets, and the assets have to be divided according to the terms of your will, then before that can happen, someone has to file a petition in the probate court and have the will accepted as your last will and testament, and then wait for a year, because creditors have 1 year from the day of your death to file a claim against your estate, and because no assets can be distributed until that year has gone by, right? We'll wait for a year, and then the assets will be distributed. But the point is, for the will to be accepted as your last will and testament, one of the presumably the person who was named as the personal representative, but in any event, someone, a family member, needs to file that will and notify the other people who would have been receiving things in the absence of the will, the so-called interested parties, that this will is being presented. And then people who may have a challenge have the right to challenge that will. And if they do challenge it, then before the will gets accepted as your last will and testament, there has to be a trial. And so even if you end up winning on a will contest, just the process of finally getting it straight, who is going to be getting what, can be really cumbersome if it goes through the probate process, and it can be really expensive. Best way to do that is to make sure that your assets do not go through that probate process. Best way to do that is typically to create a revocable and amendable trust. A revocable trust is one from which you can take out whatever you've put in. So whatever assets you put into the trust, you can always take them out while you're alive. You would name yourself as the trustee, the person who is in control of things for the benefit of certain beneficiaries, who probably initially would be you and your children. But you would say that at the time of your death, someone else, presumably one of your children or someone else, would be named as the successor trustee. And if things were structured that way, then none of the assets that were in trust would go through the probate process. Instead, the successor trustee would immediately step in and be able to distribute all the assets, and there wouldn't be this blatant opportunity for someone who was challenging your plan, your estate plan, to get that in front of a judge. So if you're thinking about especially if you're thinking about distributing things unequally, and if there's any bad blood in the family, you want to make sure that your will is done as soon as possible, or ideally you want to make sure that the will never has to get used because everything is going through probate. Every once in a while, you're going to see me glancing down because I just need to check my time. So the second really common, and I shouldn't say really common, but this probably actually the most common family feud of which I am aware is the feud between the surviving joint owner, typically the surviving joint owner of a bank account, and the probate estate. So if you die leaving assets and they go into probate, and then they're going to be subject to your will. So I have had it happen on quite a few occasions that someone will tell me, I have one child. In the case of Peter or Frank and Mary, pretend that it's Mary Jr. And there's Peter, Paul, and Mary Jr. And the will says everything gets divided equally among the kids. But my client will tell me, we have one child who's really done a lot for us, and she's, taken care of, or typically Frank has died, Mary's still alive. And she'll say, Mary Jr. is like always there. She's bringing me to doctor's appointments. She's taking care of my money. She's just taking care of me. And maybe she's even moved into the house to take care of me. And she's really sacrificed a lot. And so I want to kind of take care of her. Or maybe Mary hasn't done that, hasn't talked to me about it. Mary has simply talked to Mary Jr. and said, I really want to take care of you after I die in a special way. But I'd rather not bring that up with your brothers, Peter and Paul, because it's just going to cause a family argument, especially if there's bad blood. And so what I'll do is I'll simply put your name with mine on a joint bank account so that when I die, you'll become the owner. And that way you'll kind of be taken care of, and then nobody else will know anything. And so Mary does that, and then Mary dies. And so the will is getting probated. And somebody says, oh, what about this bank account? Because trust me, inevitably, someone's going to know about that bank account. Or someone, especially if it's the personal representative under the estate, is going to have the ability to check with the banks in the area to see if Mary had any bank accounts, and will therefore find out about that bank account. So, and at that point, the personal representative, used to be called the executor or executrix, may challenge Mary and say, that money that was in mom's bank account really should be part of the estate and should be divided up. Now, the law on this is that if you are a joint owner with someone of any asset, upon the death of that other person, you become the sole owner presumptively. But that presumption is rebuttable. And in the case of older people, That challenge, that rebutting of that presumption gets made based on typically the fact that the person is older, that their capacity may have been diminished, that they may have named this other person, in this case Mary Jr., as the successor, as the joint owner, really just for convenience, just so that Mary Jr. could kind of take care of the money for Mary, could make sure the bills got paid, could make sure that if there was an emergency that she could get to the money. That challenge it is often made. And now that challenge does not often succeed, but it does succeed in a certain percentage of the time. I would say 25 to 30% of the time that challenge succeeds. But the point is, for that challenge to succeed, there needs to be a trial. There needs to be a trial in the probate court. So the probate judge can decide whether, in fact, the money that Mary is now in Mary's name, in Mary Jr.'s name, should be given back to the estate so the money can be divided up. So how do you avoid that problem? Well, there are a couple of ways. One of them is by telling everybody, or by making some kind of note of it, that your daughter, Mary Jr., that you've made this special provision for Mary Jr. A second way, which may be the safer way because it eliminates any possibility of ambiguity after you're dead, because of course no one can ask you after you're dead, would be to put that information in your will, to say anybody who survives, who is a surviving joint owner and an account of mine, as far as I'm concerned, is entitled to that money, so that it should never be presumed that the money is going to be coming back. A third way, and I'm going to go back to where I started, would be to create that revocable and amendable trust. And in the trusts, put all the assets in trust. And in the trust, say that also. Say, look, regarding this particular account, that goes to Mary. Everything else gets divided up. One more, and this is a family feud that happens a lot, is the feud among the players regarding the way in which the personal representative, used to be called the executor or the executrix, is handling the funds. The way this typically comes up is that you die, the assets are going through probate. There's this 1-year delay. Of course, everybody in your family is, while they always said, Ma, this is your money. We don't want any of this money. But once you're dead, they're waiting for that money. It is human nature. People will always, I always refer to the fact that people are often inadvertently spending their parents' money before their parents are even dead. So in that case, you've got one of your children who is kind of taking care of everything, and the other kids just dying to get everything taken care of. And I have this happening right now between 3 sisters who were all close to their mother, but weren't really close to each other. And one of the sisters who had been taking care of the mother. And so now the sister is trying to deal with distributing these assets and is getting tremendous grief from the other sisters because things aren't happening fast enough. So there are kind of if you want to kind of be preventing that and you're the personal representative, the best thing you can do is to be as transparent as possible with the other kids. Get a conference call with all of the kids and the lawyer. Have the lawyer take the heat for the fact that it's going to take a year to get all of this done. Go through with them what the assets are, what you anticipate the bills are going to be, and then just keep them informed. If from your perspective you're worried that there may be this kind of fighting, you may even provide in your will or in this revocable and amendable trust that the person who is managing things, if the other children have problems with that, they have some way of removing that trustee. Not removing that trustee or that personal representative so that they can name themselves, because that isn't going to work out very well. But removing that that person if they think there's a problem and naming a third party. So that may be a handy way, once again, if you think there may be bad blood, if you think that this tension is going to arise, to have somebody else handle those issues. So to kind of wrap up, family feuds can typically be avoided by making sure that things are clear. You can't get rid of the bad blood if it's already there. You can certainly reduce the chance that bad blood will occur as a result of your death by trying to structure things so that assets can be distributed as quickly as possible, by providing a mechanism so that if anybody who is handling those assets is not doing a good job, that a third party can be appointed, and by encouraging whomever you're naming to be as transparent as possible. So I hope you enjoyed this presentation. These are important issues. I hope in the future to actually be able to get my colleague who does pretty much nothing but family feuds here to talk about this a little bit more. If you have any questions on any of this, once again, please free. You can always give me a call at 508-860-1470. I never charge for advice. I love giving advice. Thank you very much. I look forward to seeing you on next month's installment of Frank and Mary here in Hudson, where we're going to be talking about looking at your Medicare plan and figuring out your best plan for next year. Thank you very much.